Good morning, Moot team. Good morning, all. As we begin, we wish to remind that on the brief circulated to the teams, you would have seen the blurb on court etiquette. This contains some important guidelines. We wish to remind everyone, excuse me, come closer. Thank you. We wish to remind everyone, and especially those taking part in our 15th CCJ International Law Moot, that the core values of respect and courtesy must be extended not only to the court, but to your colleagues, the CCJ staff, and all those with whom you interact over these today. I imagine yesterday you would have interacted as well with others. So thank you very much. Madam Registrar, kindly call the matter.
Thank you, Madam President. Hearing of the 15th Annual Caribbean Court of Justice International Law Moot in the matter of Moot 003 of 2025 between the State of Antigua and Barbuda and the Republic of Guytrin. The members of this morning's panel are Madam Justice Rajnath Lee, President and Presiding Judge, Mr. Justice Jamada, and Madam Justice Ononewu. May we have the appearances, please?
Morning, Your Honors. May it please this Honorable Court, I am Ronnie Brown, appearing as Senior Counsel for the claimant, the State of Antigua and Barbuda, and I am joined by Junior Counsel Shanette Vanessa Brown, and we are instructed by Counsel Tion Huggins.
Thank you very much.
Good morning, Your Honors. I am Alexia Trim, Senior Counsel for the respondent, the Republic of Guytrin. I am joined with Sage Mitchell, Junior Counsel, and we are instructed by Miriam Salamat.
Thank you very much. The State of Antigua and Barbuda, you can come to the podium. Thank you very much. Ms. Brown?
Counsel for the claimant, and I rise to make submission seeking a declaration that the Republic of 7, 32, 36, and 46 of the revised Treaty of Chaguaramas. Oh, thank you. Okay. I will be followed by Junior Counsel Shanette Brown, who will make further submissions that the restrictions introduced by the local content policy, production sharing agreement, and the community agreement are not justified under Articles 43 and 47 of the RTC. Your Honors, with your leave, I shall proceed with my submissions.
Yes, please.
Thank you. Your Honors, this matter emanates from the Republic of Guytrin's mandation of preferential treatment for nationals of Guytrin in its petroleum sector. This is evidenced in their local content policy, production sharing agreement, and the community agreement between Hex Mobile and the indigenous people of Guytrin, which we submit are discriminatory on the grounds of nationality only and impair the rights of other CARICOM nationals to establish businesses, provide services, and seek employment as skilled nationals in Guytrin. Your Honors, I will first endeavor to establish that the LCP and PSA in tandem are in breach of the aforesaid articles, and secondly, establish the same for the community agreement. The test of discrimination in the context of Article 7 of the RTC is set out in Ellis Richards and Trinidad and Tobago at paragraph 150. The court stated that to prove discrimination on the grounds of nationality only, the claimant must establish, 1, that they were treated worse or less favorably than persons whose circumstances are similar to theirs, except for their and their comparator's nationality. 2, that there was no objective and reasonable justification for the variance in treatment. And 3, that the worse or less favorable treatment occurred in the context of activity that was within the scope of the RTC. Your Honors, in Kalanki and Bremen, the European Court of Justice held that a national rule requiring women to automatically be given priority in sectors where they were underrepresented and equally qualified to men amounted to discrimination on the grounds of sex. We submit, and counsel for the defendant accepts, that gender considerations are comparable to nationality for the purposes of assessing discrimination. However, the defendants contend that not all preferential treatment is discriminatory in reliance on the case of Helmut, Marshall, and Land Nordrhein-Westfalen. We submit that the case of Helmut at paragraph 33 can be distinguished from the facts in this present case, as in Helmut, the rule which afforded preferential treatment was saved because there was a guarantee of an objective assessment which overrode the priority accorded to those female candidates, where one or more criteria tilted the balance in favor of male candidates.
Ms. Brown.
There is no such guarantee in this case.
Ms. Brown, just wanted to take you back a little bit. My understanding is that the state of Antigua and Barbuda is claiming that there's been a breach of the various provisions cited. Can you clarify what acts of the state you're alleging constitute breaches of these provisions of the treaty?
Yes, Your Honor. We contend that it is the priority that gives rise to a nationality requirement that is breaching Article 7, 32, 36, and 46 of the RTC.
Okay, and arising from which instruments of the state or conduct, what conduct of the state is being challenged here?
That would be their local content policy. That would be the production and sharing agreement that they concluded with the private company Hex Mobile, and also the community agreement that Hex Mobile had with the indigenous group of people of Gaitrin.
Okay, and on what basis is the state of Antigua and Barbuda claiming that, let's take each in turn, that the local content policy is an act that may be challenged?
I'm sorry?
On what basis is the state of Antigua and Barbuda alleging that the local content policy is an act of the state that may be challenged?
We're doing this on the grounds of discrimination on the grounds of nationality only.
So no, to be more specific, the other side, the state of Gaitrin, is claiming that the local content policy is not mandatory. It's just stating objectives and principles. So on what basis is the state of Antigua and Barbuda alleging that this is an act of the state that may be challenged?
Your Honor, it is our contention that the LCP and the PSA are mandations, are mandatory. If you look at the language that they're using, it says shall. So it's not discretionary.
Ms. Brown, I don't think you are quite responding to the question. Let's stick with, first of all, the
Sorry, I cannot hear you.
LCP.
You need
Let's stay
someone
with the
to speak.
LCP. Are you hearing me?
I can hear you now, yes.
Let's stay with the LCP. Why is the LCP an act of state? What makes it an act of state?
It's a national rule that the state of Gaitrin implemented to oversee or put perimeters in place for their petroleum sector. So this is their policy promoting how activities are supposed to take place within their petroleum sector. This was instituted by the government.
Executive, right?
Sorry?
This was issued by the executive.
Yes.
Is there any authority that suggests that a policy statement by the executive can constitute an act of state?
Yes, sir.
Because it's not a law. It's not, no, it's just a policy statement.
Your Honors, it is our contention that any measures that are put in place does not have to be enacted into legislation in order to violate your treaty obligations. And we draw the court's attention to the case of Tomlinson, whereas the court would have referenced Articles 8(7) and spoke to the fact that administrative measures or legislative measures or conduct can violate treaty obligations. So it does not have to be just legislation enacted.
Okay.
Thank you. What do you tell us about the community agreement then? How is that a reach?
Yes, with regards to the community agreement, we're stating that because the community agreement encompasses the discriminatory provisions that are within the LCP and the PSA, we're contending that it also is discriminatory on the basis of nationality. And we're also stating that it is attributed to the state as well.
Are you saying that the LCP mandated the entering of the community agreement?
We're saying that the community agreement is a byproduct of the LCP, Your Honors.
But made between, not, the state is not directly involved.
The state is,
Agreement was made between Hex Mobile and
ExMobile and the people of Guytrin, yes. However, the state can still assume responsibility for private actions of companies that have resulted from their policies that they have put in place. And we draw the court's attention to Article 8(7) of the, just get it for you, one moment for me. Yes, Article 8(7) of the International Law Commission's draft articles on responsibility of states, which state that a state, either by specific directions or by exercising control over a group, in effect assumes responsibility for their conduct. And we also draw the court's attention to the case of Commission in Ireland, where the court held that the government could not rely on the argument that a campaign conducted by a private company can be used as a means for escaping liability. Therefore, we submit that the LCP, setting out the general parameters for participation in Guytrin's petroleum sector, particularly concerning the recruitment and procurement process, and how they are to execute petroleum activities. And two, the government of Guytrin's concluding the PSA agreement with Hex Mobile, specifying or setting out the perimeters for the company's participation in the petroleum sector amounts to direction by the defendant, which undoubtedly resulted in the discriminatory provisions laid out within the community agreement. Accordingly, we submit that the provisions within the community agreement are attributable to the defendant. So just because it's a private company does not mean you can escape liability in that way based on these authorities.
You mean Guytrin?
Guytrin, yes, Your Honor.
and you source the control. You remember the test that you set out from Article 8(7)?
Yes, sir.
And you place the control in the PSA. What evidence is
The direction,
Yeah.
yes.
Okay, good.
Yes, Your Honor, that's what we're saying. The LCP sets out the perimeters of how you are to act in the petroleum sector in Guytrin, and then they then go on to conclude an agreement with Hex Mobile, that private company, and they make it clear this is how you are to deal with recruitment and procurement in accordance within our petroleum sector. And then Hex Mobile now then goes to the people of Guytrin and said, this is how we're going to also provide for you and give preferential treatment in that way.
The community agreement is wider or narrower, depending on how you frame it, than what the PSA requires, or the LCP. For example, the PSA says that you give preference where bids are competitive, et cetera, in the fact matrix. So in other words, the agreement between the state and Hex Mobile had a condition for preferential treatment.
Yes, that is to provide Guytrinians with more, whoever gives Guytrinians more business opportunities and so forth, they would get the preference.
Provided the bids are competitive, etc. The preference is only triggered provided bids are competitive and there are resources, etc. All of those conditions must be met in order to benefit from the preferential treatment. Agreed?
It is our contention, Your Honor, if I understand.
The factual matrix, paragraph 1, 2, 3, 4.
Okay,
Mhm.
go there. Yes, which paragraph, Your Honor?
Is, fourth paragraph, is, third line, is required to give preference during the bidding process. Yes?
Sorry, Your Honor, I'm trying to follow exactly where you are.
The fourth, in the factual matrix, paragraph 4, it begins also in 2020.
Yes, I'm there.
Third line, is required to give preference to suppliers
Under the PSA, yes.
where their bids are competitive, foreign bids in skills, resources, availability, and price, and meet its technical and financial requirements.
Yes.
So, to benefit from preferential treatment, you must also meet these requirements.
Yes, yes, Your Honor. However, that just says,
Is
okay,
Is the agreement limited in that way, or is it even broader? The community agreement.
the community agreement, Your Honor, we contend that it does give preferential treatment and that those items that you,
Any limitation, or does it simply says commits to giving preference?
permits means that they are going to do it. That's their contractual obligation.
There are no limitations. But the PSA has limitations, doesn't it?
Your Honor, what the PSA lists out actually puts persons on equal footing.
Yes.
So it's still the nationality requirement in giving preferential treatment to the Gaitrinians. That is the issue at hand, and that is what is in the community agreement.
All right, yeah, let's move along.
Yeah, and Ms. Brown, time is going. So if you wish to go, if you have anything more important to tell us under your first issue, you may go ahead for a very short while, but you may want to consider going on to Articles 43 and 47, but you're not doing that. Your junior is doing
Council
it.
will deal with
So
that,
you
Your
have
Honor.
Article 7 and so on? Yes.
Yes, Your Honor. Yes, Your Honor. I would love
But
to.
time is running, yes.
Okay. Okay, it's not there. Okay. So, Your Honor, I would just like to now move on to state that go back to the first limb of the test. So we would say that therein, in relation to the first limb of the test in Ellis and Richards and Trinidad and Tobago, the claimant submits that the LCP and PSA, by mandating petroleum operators and their contractors, give preferential treatment to Gaitrinians and Gaitrinian suppliers amounts to less favorable treatment being provided to nationals of other member states. As it concerns the second limb of the test, this court in Richards and Ellis again made reference to the case of Ryanair and the European Commission at paragraph 82, where the General Court opined that any measures implemented must enable the objective to be achieved and not go beyond what is necessary to attain it. And Your Honors, the facts are clear that the Republic of Gaitrin implemented the LCP with a view to ensuring that the exploitation of their petroleum sector, well, their petroleum activities benefited Gaitrinians, of course, and for sustainable development, while the PSA is concerned with development of Gaitrinians in all areas and sector, and also to minimize employment of foreign personnel in the petroleum industry. On this basis, the claimant respectfully submits that there's no objective and reasonable justification for the implementation of this preferential treatment stipulated in the LCP and the PSA. The defendant's approach it is our contention that their approach is to segregate its petroleum sector, whereby the RTC aims to foster regional development through cooperation and the improvement of access by nationals of member states to all resources of CARICOM countries without discrimination.
Ms. Brown,
No, you go ahead.
Brown, thank you. I'm particularly clear on the arguments with respect to Article 7. In the interest of time, I wanted you to clarify for me how the state of Antigua and Barbuda considers the training or capacity development requirements in the various instruments, the LCP, the PSA, and the community agreement, to restrict the exercise of the various rights of the community nationals, whether it's the right of establishment, right to provide services, or to seek employment as skilled nationals.
Your Honors, as far as the training is concerned, the GUITRIN has mandated that GUITRINians are to be trained within that sector only. And in the case of Cabral Douglas and the Commonwealth of Dominica, I apologize, the court opined that this right extends to persons traveling for the purpose of education. So it basically says you are considered a recipient of services if you're going for educational purposes. So they would be restricting persons from being trained in the petroleum sector under Articles 36, because if you're traveling to get, I am not a national of GUITRIN, it is clear that I cannot receive that service. So that's how that would be in that regard.
Any restrictions being placed on service providers? So I understand your argument to be the service consumer. If you are seeking to consume those services, what about if you're the service provider?
Yes, Your Honors. It is our submission that the LCP and PSA, by requiring petroleum operators to give priority to GUITRINian suppliers, to train GUITRINians only, and to minimize the employment of foreign personnel, impose new restrictions on the grounds of nationality. This imposition of such restrictions amount to less favorable treatment to nationals of member states and hinders their right to provide and receive services, inclusive of receiving the educational training in the petroleum sector. So if I owned a supplier's company or so forth, and I wanted to supply Hex Mobile with certain things, I will not get that opportunity just because I am not GUITRINian, because it goes to them first. So where there are, say, 5 companies bidding for to supply Hex Mobile, once those companies are GUITRINian, I do not have a chance.
So in other words, you consider it to affect the competitive conditions?
Most definitely,
Thank you.
Your Honor.
Good. We're seeing that you have just about half a minute, so
Your Honor,
if you would
I will
wrap up. We have asked
definitely.
several questions of you, so we will allow you a couple of minutes, and I mean 2. Yes.
Thank you, Your Honor. I would just like to touch on Articles 46. In this regard, it is our contention that also pertaining to the skilled community nationals of other member states, they are also hindered from seeking employment within the petroleum sector of GUITRIN because the LCP and PSA, again, require employment of GUITRINians with priority and the minimization, again, of employment to foreign personnel. Therefore, the imposition of nationality requirement is, again, in breach of Articles 46. Therefore, Your Honors, in conclusion, based on the foregoing submissions, the claimant seeks a declaration that GUITRIN has breached Articles 7, 32, 36, and 46 of the RTC, and we're asking for cause. Your Honors, unless I can be of no further assistance, these are the extent of my submissions.
You asked for course. Thank you.
Thank you.
Okay. Thank you very much. Your counsel may come. Ms. Brown?
Good morning, Your Honors. May it please this honorable court, my name is Shanette Brown, and I appear as junior counsel for the claimant. I will be addressing the court on whether the local content policy, the production sharing agreement, and the community agreement are justified under Articles 43 or 47 of the revised treaty. Your Honors, as submitted by senior counsel for the claimant, we contend that the measures in question are discriminatory on the grounds of nationality only and impairs the rights of other CARICOM nationals to establish, provide services, and seek employment as skilled nationals in GUITRIN. We further submit that on this basis that the measures are not justified by Articles 43 or 47 of the revised treaty for the following reasons. In order to justify a restriction under Article 43, there are several conditions that the defendant must satisfy. Firstly, there must exist a serious balance of payments and external financial difficulties or threat thereof. According to the facts of this case, at the time of the first significant oil discovery, GUITRIN was battling a serious economic crisis. And for decades, the country had unsustainably high levels of external debt and participated in the International Monetary Fund program. However, the facts suggest that since the discovery and commercial production of oil in 2021, the defendant's financial situation has improved. Therefore, while Guytrin faced financial instability before 2019, we contend that the difficulties which Article 43 is intended to address no longer exist to justify the application of these restrictive measures under this article.
So is it then that you are accepting that at inception they may have been justified in the restrictions?
Our contention is, even if those restrictions were justified at that time, Your Honor, the measures in question have gone beyond what is necessary to remedy these circumstances. And they have been in place for an indefinite duration.
If that is so, then at the time of the making of the LCP, PSA, and community agreement, is it then that under the Richards test that there must be an objective justification? There could have been an objective justification at that point in time, and your argument is, even if that is so, it's no longer so now. I'm just trying to clarify whether your team's approach is that at inception, there may have been justification both under the Article 7 test and under Articles 43 and 47.
I understand, Your Honor. We contend that at the time of the oil discovery, a year following, in 2020, is when the first measures were issued. And at this time, it was too soon for example, the defendant state, as a state dependent on natural resources, may fear their resources running out. However, at the time of discovery and at the time of implementing the first measures, there was no evidence that the natural resources would run out. It was too early at the time of discovery and at the time that they implemented these measures to say that that was an objective. What these measures seek to achieve is objective, to achieve the objectives.
Thank you.
But at the time, the balance of payments was an issue in Guytrin. And it's not what 43 directs us to. So,
Yes, Your Honors. However, in 2019, based on our fact pattern, the defendant had unsustainably high levels of external debt and participated. And this suggests that these issues previously existed and as such is not captured by Article 43. And we contend that since 2021, when Guytrin began commercial oil production, this would have significantly increased their financial situation.
But they made the agreements in 2020 after the discovery in 2019. And they only started production, I believe, in 2021 after the agreements were entered into. So we won't press it further, but I just sense that you were accepting that at a certain point of time, they may have been justified, but with the passage of time, you brought your case in 2024, correct?
Yes.
So by 2024, you say whatever justifications may have existed, they didn't exist in 2024. Is that what you're saying?
Your Honors, to clarify, we do not agree that at the time the measures were implemented, that they were justified based on the circumstances being asserted. And we further submit that the measures are preemptive, especially given the fact that when the measures were put in place, the petroleum industry in of itself was not opened to other CARICOM nationals. And on that basis, the measures were implemented preemptively.
Ms. Brown, can I ask you about a particular condition under Article 43(2), and that relates to the restrictions having to be non-discriminatory?
Yes.
Now, in the written submissions, and here I'm looking at paragraph 8, seems like the state of Antigua and Barbuda is contending that the measures are discriminatory because they discriminate in favor of Guytrinians.
Yes.
I just want to clarify if that's your understanding of what the standard of non-discrimination is under Article 43(2)(a).
Our interpretation of Article 43(2)(a) is that the restrictive measures put in place must not discriminate among all member states, in that when whatever restriction is put in place must apply across the board.
And
That
does,
is our understanding.
and do the initiatives in question satisfy that requirement?
No, Your Honors. However, in terms of the other conditions, for example, 43(2)(c) and D, there's other conditions, other prohibitions set out under Articles 42(a) to D that must be satisfied.
But just specifically where A is concerned, are the measures non-discriminatory?
The measures are discriminatory under Articles 47. However, based on the interpretation and the meaning of Article 42(a), in that they must apply across the board, we contend that it's not discriminatory on that basis.
Thank you.
What do you tell us about Article 43(4) and the notification that
Yes, Your
ought
Honor.
to be made? Mhm.
Where a member state intends to implement a restrictive measure, they are required to notify COFAP and COTED of their intentions. And we contend that this condition is of a fundamental nature, as it ensures that the restriction imposed is imposed for a legitimate reason and that the measures taken are proportionate. Moreover, the restrictive measures are subject to COFAP's powers to implement periodic consultations for the eventual removal of these restrictions. And this speaks to the importance of these organs being notified before these measures were put in place.
Do you look at it, ma'am, as a mere formality?
Not as a mere formality, Your Honor, but a fundamental formality that should have been met by the defendant
Is there any,
for the justified application of these
is there any
restrictions.
jurisprudence that supports that contention? That these procedural requirements are not just a mere formality, but precondition? Because it's clear they have not been complied with, yes?
Yes.
Yeah.
Your Honors, we submit that under Article 9 of the RTC, when a member state signed and ratified, that they agreed to abstain from implementing measures that would frustrate the aims of the community and would put measures in place to achieve the objectives of the community, Your Honor. And as such, moreover, as mentioned, COFAP can make recommendations for the eventual removal, and coupled with the requirement under 43, coupled with the requirement to notify and their commitments under Article 9, we submit that this notification was fundamental in order to not frustrate the aims of the community.
So let me ask you something. There's a requirement for notification, clearly, in both 43 and 47.
Yes.
How do you reconcile what happened on the facts? That is to say, in 2022, prior to 2022, there were complaints, and the heads of government of CARICOM created a working group on local content to make recommendations regarding the development and application of local content legislation, policy, and plans, i.e., documents exactly like the LCP, PSA, and community agreement. So would you agree that even if the formalities were not complied with, in fact, COTED and COFAB and CARICOM had notice of the existence of the LCP, PSA, and community agreement in 2022 and actually established a mechanism to do what 43 and 47 intend when notice is given? How do you reconcile that?
Even if these even if notification is assumed by the conference, Your Honor, the measure in question, the restrictive measures in question have still gone on for an indefinite duration. They have gone on for an indefinite duration and they were preemptively put in place contrary to the purposes of Article 43 and 47. For example, in order to justify restrictions under Article 47, the rights in question, and in our case being 32, 36, and 46, should have caused the difficulties being asserted. However,
Have they been countenanced by the heads of government? They know, has all that been countenanced by the heads of government? They know about all of it, and they say, okay, we're going to set up a working group to make recommendations. So the status quo continues. They didn't say, let's put in place an interim measure, you know. Can it be argued that the community has countenanced what is in existence as impliedly justifiable because of what happened in 22? I'm just asking you how you respond to that, because this is part of the factual matrix, right?
yes, if I understand your question correctly, Your Honor, do you mind rephrasing your question, Your Honor, please?
Yes. The heads of government intervene
Yes.
on this very issue. They
Yes.
are aware of everything that is happening, and they set up a working group, but don't do anything to stop it or put limitations or put conditions on what is going on. Can it be argued that that is, in fact, the heads of government accepting that this is a situation that can continue indefinitely until we work it out, i.e., the working group comes back and says what should be done, because they're aware.
I disagree that it is acceptable even if they have noticed and even if they have put this conference in place, Your Honor. A member still has a certain level of autonomy to safeguard its internal situation. However, this must be consistent with its international obligation. So the convening of this meeting, we suggest, is to provide recommendations for these restrictive measures, for example, a local content policy, to be consistent with the provisions under the RTC.
Okay.
Yeah, we follow you. Thank you, ma'am. I see that you have just a minute left, but we'll give you a couple more because we have asked a lot of questions.
Yes, Your Honors. We contend on the basis of Article 43 that the claimants are not that the restrictions are not justified by Article 43, as the defendant has not satisfied the requirements thereof, to which the defendants have conceded, Your Honors. Additionally, the defendant submits restrictions implemented. The claimant submits, Your Honors, I apologize, that the restrictions implemented under Article 43 do not extend to the rights under Article 46, and as such cannot be used as a basis for impairing the rights of skilled nationals. Moving on to Article 47, Your Honors, as previously mentioned, the difficulties being asserted by the member state, those difficulties should have arisen by the exercise of the Chapter 3 rights, Your Honors. Moreover, we similarly contend that the defendant has failed to satisfy the requirements under Article 47. For example, at Article 47(5), the restrictions must be limited to those necessary to resolve the particular difficulties in the affected sector. This is essentially a test of proportionality, and we submit the case of Gebhard that is applied by the ECJ to determine whether a measure that hinders a fundamental right is proportionate and can continue to be maintained by a member state. And it was suggested, a four-limb test was established, Your Honors, which includes which includes that the measures must be necessary to achieve the objective and must not go beyond what is necessary. And in this case, we submit that the rights in question did not cause the difficulties being asserted by the defendant, and that the measures under Articles 43 and 47 are preemptive, have been in place for an indefinite duration, and are discriminatory. And Your Honors, if measures of this nature is allowed to stand, it has the potential to frustrate the aims of the community and economic development, as they impose new restrictions, namely a nationality requirement to exercise the right of establishment, the right to provide services, and the movement of skilled nationals. Your Honors, based on the foregoing,
Yes, go
the
ahead.
claimants seek a declaration that Guytrin has breached Articles 7, 32, 36, and 46, and we also seek costs. If I may be of no further assistance to this court, these are the extent of my submissions.
Thank you
Thank you.
very much. Yes. Could someone check the podium? We're getting a click or sound on the mic. Yeah, which is not normal. It may be that the mic is too close, I don't know. But it is disturbing. Thank you. The Republic of Guytrin, Senior Counsel. Thank you.
Good morning, Your Honors. I am Alexia Trim, Senior Counsel for the respondent, the Republic of Guytrin, and I am here today to seeking that we have all claims dismissed in this matter. From this matter arises two issues. The first, which I will address, is whether the local content policy, local content provisions of the production sharing agreements and community agreements are in breach of Articles 7, 32, 36, and 46 of the revised Treaty of Chaguaramas. My junior, Sage Mitchell, will address the second, which should this court find any such breaches, that these breaches are justified by Articles 43 and 47 of the RTC. Your Honors, with your leave, I will now begin my submissions.
Yes, please. Thank you.
Article 7 of the RTC prohibits discrimination on the ground of nationality only. It was this Honorable Court in Cabral Douglas that stated that Article 7 did not confer an inherent right, but rather provided the rule by which the framers of the treaty intended to ensure that rights granted were not distorted by discriminatory actions. It is for this reason today that a substantial part of my submission centers on analysis of Article 7 with respect to the three disputed documents. In doing so, we apply the test espoused in Ellis Richards and the States of Trinidad and Tobago at paragraph 150. Article 7 requires the fulfillment of three grounds. 1, that they were treated worse or less favorably than persons whose circumstances were similar to theirs, except that of nationality. 2, that there was no objective or reasonable justification for the difference in treatment. And 3, that the worse or less favorable treatment occurred within the scope of the RTC. I begin now with the local content policy. Ground 1 requires that there be discrimination on the grounds of nationality. Worldwide and certainly within the region, local content policies are used throughout industries. Within the
Ms.
Caribbean,
Trim, before you continue, please, because this question I'm going to pose cuts across all of the provisions. Before we tackle whether the particular articles of the treaty have been breached, what is the position of the state of Guytrin with respect to whether the local content policy, the production sharing agreement, and the community agreement are actually acts of the state that can be challenged? Is it that, what is the position of the government on that issue, please?
We submit for the production sharing agreement and the community agreements are not attributable to the state of Guytrin pursuant to Article 8 of the ILC draft Articles on State Responsibility. With regard to the local content policy, we submit that it does not amount to a restriction pursuant to the revised Treaty of Chaguaramas, as it is non-mandatory and non-punitive.
Okay, so you not concede, you maintain that the local content policy is an act of the state, but not the production sharing agreement or the community agreement.
Yes, yeah.
Can you clarify why the other two instruments, the production sharing agreement and the community agreement, why Guytrin maintains that they're not acts of the state?
The Hex Mobile is not a CARICOM national, nor is it a Guytrin national pursuant to Article 32.5 of the RTC. Furthermore, there is no element of control present with regard to either the PSA or the community agreement. With regard specifically to the community agreement, there is no element of control or involvement at all by the state of Guytrin.
Let's go back to the production sharing agreement. What's the relevance of Hex Mobile not being a community national to the
Hex-
question of whether there can be attribution to the state? Why is that relevant?
Hex Mobile is not a national, and this is relevant since it indicates that there is a distinction between a further distinction and divide between Hex Mobile's acts and the acts of the Republic of Guytrin.
So is it that the acts of a non-community national could never be attributed to the state? So is it that a state can't exercise influence or direction or control over a non-community national such that its actions can be attributed to the state?
While this is allowed under international law, we submit in this case that there is no element of control within the PSA or any element of direction that indicates that Hex Mobile was acted on behalf of the state of Guytrin.
But where the production sharing agreement is concerned, isn't this a contractual arrangement entered into with the state?
Yes, and we acknowledge that Hex Mobile exercised its discretion in its discretion and autonomy in entering into that agreement.
Okay, and where the community agreement is concerned, could you just reiterate why the state of Guytrin doesn't consider this to be conduct that can be attributed to the state?
Your Honor, from the present facts, there is no indication that the Republic of Guytrin involved or persuaded Hex Mobile to draft these documents in favor of the indigenous people.
Thank you.
Yeah, what about the training of Guytrinians by Hex Mobile? What is your position with respect to that training and the articles that you reference?
We submit that there is no restriction that, evident from the facts, there's no restriction that Guytrin nationals alone can be trained. And this is also seen in the fact that should successful applicants from other CARICOM countries be hired or their contracts be accepted, that they would also have the opportunity to be trained by Hex Mobile.
So you say that other CARICOM nationals can come to Guytrin and be trained?
Yes,
That is your
we,
point.
we,
Yes, we follow you. Thank you. You may move on.
thank you. Still on ground one of the test as it relates to the local content policy, we see that it is utilized across industries within the region, and we rely on the article cited by the applicants that highlights the deepwater production sharing contract, for instance, of Trinidad and Tobago, as well as Guyana's Local Content Act. It is evident, therefore, that Guytrin's policy is not unique to the region. The objective justification moving to ground two of the LCP is clear. The policy is not
Ms.
only
Trim, I just want to make sure I am clear on the point. So you're saying that the existence of similar policies or initiatives throughout the region suggests that there may be no violation of Article 7? I just want to make sure I'm clear on the argument.
yes, because we consider this to be comparable circumstances in which there is no discrimination.
but for the purposes of Article 7, are the comparators the measures being taken, or are the comparators the beneficiaries of the treatment? Are we comparing the regulation or the measure of country A and country Y, or are we comparing the treatment of the nationals of other CARICOM countries with the nationals of citizens of the country in question?
We submit that it is the treatment, but the treatment is interpreted through the measures that the countries have implemented.
Okay.
We submit that the local content policy is necessary for the benefit of Gaitrun and the wider community to derive maximum benefit from this location-specific industry. The training of Gaitrun nationals can be beneficial to other CARICOM states. Furthermore, improvements to Gaitrun's economy can increase purchasing power among nationals and the state of Gaitrun, leading to increase in consumption of community goods. Economic advancements would also improve Gaitrun's participation in CARICOM. As it relates to Ground 3, which we had previously discussed, the applicants rely on...
Before you move off, in the factual matrix, is there any anchoring of the objective and reasonable justification in what was the state of the economy of Gaitrun in 2019 going forward?
Yes, Your Honor, we submit that within the facts, the economic downturn that Gaitrun had been experiencing for years does in fact justify the need for the local content policy and the production sharing agreement to some extent. We submit that the Commission on Ireland must be distinguished on two grounds: the flexible wording of the LCP as compared to the Irish campaign, and the nuance of the hiring process. The wording of the LCP contains phrases such as adequate opportunity and first consideration. This indicates flexibility, and it allows HEXMOBILE, any company, discretion in how they choose to hire their workers. Contractors and employers are not expected to bypass their usual regulations in favor of hiring Gaitrunians on the basis of nationality only. Secondly, we reject the idea that purchasing products and hiring nationals are comparable. For instance, the Buy Irish campaign led to the stratification of goods, automatically granting Irish products a more superior status. There can be no such clear delineation of prospective workers, especially as employers seek a wide range of attributes.
My understanding here is that this idea of nationality only, it doesn't reach that threshold because the language is sufficiently flexible to be more inclusive.
Yes, Your Honor.
Yeah, okay.
Moving to the first ground of the Ellis Richards test as it relates to the production sharing agreement. It requires that the discrimination take place on the basis of nationality only. This honorable court acknowledged the importance of such in Shanique Myrie and the state of Barbados, and this is likewise noted by Professor Berry. From the facts, there is no evidence that indicates an expectation, likewise with the LCP. There is no evidence that indicates an expectation of hiring or acceptance of contracts on the basis of nationality only. Employ with priority that only illustrates a slight advantage and is likely necessary to dissuade the hiring of foreign personnel such as American workers or other non-CARICOM nationals.
So, Ms. Trim, you don't consider these measures to modify or affect the conditions of competition in favor of Gaitrunians?
No, we do not accept that it places Gaitrun nationals at an immense advantage, especially as it relates to the objective justification, considering that Gaitrun would have had economic downturn for so long and considering that this is an emerging industry and still in its initial years. it is likely that Gaitan nationals would have lacked the requisite expertise and skills necessary for the petroleum industry. This leads me to the second ground of the test as it relates to the production sharing agreement, which aims to bolster foreign direct investment and thus makes it reasonably justifiable. The nature of the oil and gas industry, which my junior will divulge in more detail later on, is one that is not only location specific, but does not result in substantial products upon inception. Relying on the article by Ruth 9, many countries aim to profit as much as possible within the initial years without any regard for long-term development. By prioritizing Gaitan nationals, the state aimed at developing its human resources. As it was previously stated, it is likely that many nationals would have not had the requisite skills or experience in this novel industry. Further, we submit that should Gaitan have implemented a provision that gave priority to all CARICOM nationals, that this could have likely been onerous on ExxonMobil and thus dissuaded foreign direct investment. There's also no guarantee that Gaitan would have benefited from the long-term development should this provision have been implemented, since there's no guarantee that these CARICOM nationals would have stayed in Gaitan in the long term.
So Gaitan is arguing that the local content policy, that the absence of a local content policy might actually have served as a disincentive to foreign investment. I want to be clear on what's being argued.
We submit that it was necessary for their long-term development, considering their economic standing, and in order for them to have a fair advantage in deriving maximum benefit, it was necessary to be implemented. I move now to the community agreements with regard to the ground one of the Ellis-Richards test, which requires nationality to be an important factor. However, we submit that the treatment meted out is based on their indigenous or cultural identity, which can extend beyond borders. This honorable court emphasized the importance of specialized rights for indigenous people in the case of Maya Leaders Alliance and the AG of Belize. This location-specific industry carries immense environmental risks, and this community agreement seeks to give benefits to the indigenous people within the immediate area of the exploitation of the oil and gas resources.
Ms. Trim, clarify something for me. I thought Gaitan was arguing that the community agreement couldn't be attributed to the state.
We do still hold that, Your Honor,
Right.
that position.
Okay, thank you. And so the arguments being made about the protection of indigenous rights, they're being made for what purpose?
For the sake of a thorough argument, Your Honor, we looked at all three grounds of the Ellis-Richards test as it related to all three of the disputed documents. However, we still submit that the community agreements are not attributable to the state of Gaitan.
Thank you.
Continuing from that,
So that just to be clear, in the alternative, if it is attributable, if we find it is attributable, it is reasonably justified.
Yes, Your Honor.
Objectively and reasonably justified.
Yes, Your Honor,
Yeah.
because
Yeah, we know, okay, we understand, move on.
as Your Honor just mentioned, it is also reasonably justifiable because international courts, including this honorable court, the Inter-American Court of Human Rights, and the UN Declaration on the Rights of Indigenous Peoples, all acknowledge that there's a special connection between the indigenous people and their land, and therefore ExxonMobil's community agreements seek to give advantages to the indigenous people in exchange for the exploitation of their resources. Therefore, we assert that the local content provision, the local content policies of the production sharing agreement and the community agreement are not in breach of Article 7. Consequently, the substantive rights annexed, which are Article 32, the rights of establishment, Article 36, the right to provide services, and Article 46, the right of free movement of skilled workers, have not been breached by any of these documents. There are no barriers to entry. Therefore, the full enjoyment of Article 46 is available within the state of Guytrin, and successful applicants and bidders are welcome under Articles 32, 36, and 46 of the RTC. The Republic of Guytrin stands firm in upholding the rights conveyed by the RTC for the advancement of the state and the CARICOM at large.
Ms. Trim, just a quick question. If the court, is it possible that the court could find that a measure doesn't discriminate on the ground of nationality only, but the measure nonetheless impairs the exercise of the rights of community nationals under Chapter 3 of the treaty? Is that possible? I see the linkage being made by the state of Guytrin. I understand it. I just want to be clear. Is it possible that the court could find, well, a measure doesn't discriminate on the ground of nationality only, but we find that it does impair the exercise of the rights of community nationals under Articles 32, 36, and 46? Is that possible?
That is possible, Your Honor, but we submit relying on Tomlinson, in which the laws, even though they were discriminatory on its face, were not a breach of the obligations of the state pursuant to the RTC.
Okay.
Yes. You have a little less than a minute, Ms. Trim, if you wish to.
Your Honors, I wish to reiterate that the Republic of Guytrin stands firm in upholding the rights conveyed by the RTC and for the advancement of the state, the Republic of Guytrin, and CARICOM at large. Your Honors, unless I may be of further assistance to this court, this now concludes my submissions. With your leave, I will invite my co-counsel, Sage Mitchell, to address the second issue.
Thank you very much, Ms. Trim.
Your Honors, with your leave, I wish to address the second issue of this matter, whether, if any violations are found, they may be justified under Articles 43 and 47. It would be remiss of me not to remind that the position of counsel for the Republic of Guytrin is that there are no violations of Articles 7, 32, 36, or 46. However, if any violations are deemed by this honorable court, we would like to assert that they are justified under Articles 43 and 47. To begin, I turn your honors to Article 43, which permits restrictions to safeguard the balance of payments. Specifically, its application requires serious balance of payments or external financial difficulties. At the time of the imposition of these restrictions, these conditions clearly existed within Guytrin, as evidenced by their low foreign currency reserves, fluctuating commodity prices, rising levels of unemployment, participation in the IMF program for highly indebted poor countries. We would like to further assert that on a balance of probabilities, the prevailing conditions in Guytrin are sufficient to qualify this restriction. Relying on the Rupnerine article, it is emphasized that there are challenges for new oil-producing countries to realize the benefits of their productions. Specifically, multinational corporations such as ExxonMobil habitually abuse the inexperience of these first-time oil-producing countries, such as Guytrin, who sign on to predatory, one-sided agreements which have the effect of expatriating most of the profits from oil and gas, which could have been used to bolster their economies. Furthermore, Guytrin's oil discovery was in line with the timing of the COVID-19 pandemic, which had the effect of unfavorable variances in the global oil prices. These factors considered, Guytrin is unlikely to have seen significant changes in its economy within this period, and a serious balance of payments and financial difficulties subsist, allowing for the application of Article 43. Counsel for the applicant posits that Article 43 is inapplicable on the ground of discrimination, as prescribed by Article 43(2)(a). However, I turn to the arguments put forward by my senior that in reliance on the test established in Ellis Richards against the state of Trinidad and Tobago, the restrictions meted out by GUITRIN are not discriminatory and especially do not favor third states. Moreover, considering Article 43(2)(b, the restrictions will have little to no effect on the commercial, economic, and financial interests of other member states. As expressed by my senior, these restrictions in no way impact nationals of other member states from entering, establishing businesses, or providing services. Moreover, there is no outright ban on the employment of other community nationals, so the possibility exists for their employment within the petroleum industry in GUITRIN. To add, bearing in mind Article 43(2)(c, the restrictions are necessary to deal with the situation in GUITRIN. Considering the high unemployment levels, there is a definitive need to train and employ with priority GUITRIN nationals. In the Pereira and Elias Roberts article, we see that the local content policies can increase diversification, allow for development, and they may eliminate weaknesses in the factors of production, help generate employment, and remunerate those affected by the exploitation of their resources. Furthermore, it was this honorable court, in its appellate jurisdiction in the case of Maya leaders against the AG of Belize, where it was emphasized that there is a need to grant specialized rights that empower indigenous people to control their land and resources. In this way, the LCP, local content provisions of the PSA, and community agreements are necessary to deal with the situation in GUITRIN.
Ms. Mitchell, it's a very interesting argument. I just want to be clear on something. So this standard of necessity, if we use that term lightly, which appears in both Articles 43 and 47, does that standard require the court to look at the availability of reasonable alternatives, the reasonable availability of alternatives to achieve or to address the external difficulties? And is that a burden that that GUITRIN as the party invoking this exception would have to meet?
Yes, Your Honor. It is logical for the court to consider alternatives. However, in the present circumstance, it does appear that it would be logical and lending towards necessary for these restrictions imposed in GUITRIN.
Okay, so there are some submissions which have been made with respect to that invite the court to take into account the nature of the sector in question. And I found interesting the parallel being drawn to the position of indigenous peoples. Is the court almost being invited to think of the state of GUITRIN as a state that almost needs to take affirmative action type measures at the stage of oil discovery?
Your Honor, specifically regarding the community agreements, I would agree that the state should do the affirmative measures considering the esteemed importance of upholding these rights for indigenous persons. And the petroleum industry is location specific. So there is no real alternative than giving specialized rights to the GUITRIN indigenous persons whose land and resources will be utilized and exploited.
Ms. Mitchell, and probably the final question I have on this is there's a reference in paragraph 12 of the submissions of GUITRIN to GUITRIN being a less developed country. What's the basis of that argument, and what is the relevance, if any, that the court is to assign to this?
Your Honor, we assert that GUITRIN is a less developed country considering the definition as provided by Article 1.
But are less developed, the term less developed countries in the treaty has a very specific meaning. It's certain designated countries. GUITRIN isn't designated as a less developed country in the treaty. Is there any other categorization that GUITRIN could fall under? And if it could, would that categorization be relevant in any way to the court's deliberations?
Yes, Your Honor. We are of the position that the list of countries designated as less developed countries may be subject to change as per the treaty Article 4. However, beyond that, the GUITRIN may be considered as a highly indebted poor country, And as a highly indebted poor country, the special regime may be applied to Gaitrin, which was the main takeaway from our designation as a less developed country. So if Gaitrin is established as a highly indebted poor country by a competent organ, as it was participating in the IMF program, the regime may apply, and we are using it to justify the failure outlined by the applicant of phasing out and removing the restrictions within 18 months.
Okay, so Gaitrin wouldn't be a less developed country. It could be a disadvantaged country. Could you, as by virtue of it being a highly indebted poor country, could you just elaborate, if you can, on what significance the court should assign to this? Do you consider the classification of a country as a disadvantaged country to be of any relevance to the court's assessment of whether that country could invoke the exceptions in Articles 43 and 47? That's my specific question.
Your Honor, the designation of Gaitrin under that heading would allow for the application of the special regime, which we seek to use as further justification to displace the fixed quota for the removal and phasing out of restriction.
Did you say fixed quota?
The fixed quota, Article 43 2D, provides that the restrictions must be phased out and
Okay.
removed within 18
Okay.
months.
Thank you.
Yes, you may move on.
Okay. Moving on from this special regime. Okay. So at this point, I would look to Article 43.3, which says that the restrictions must be priority can be given to activities mandatory for economic stability. Considering the prior article, we are reminded that local content policies are important to assist in the development of nationals and businesses in developing countries. And this facilitates building capacity to perform jobs internationally, which will obviously further earnings and economic stability. In its present state, Gaitrin's economy heavily relies on the adequate development of its petroleum industry, and the restrictions in this industry do not serve solely to protect the sector, but instead to see to the essential stabilization of the economy of Gaitrin. Moreover, the question arose as to whether Gaitrin undertook to notify the relevant organs. And this argument, I would ask that is posited for both Articles 43 and 47 in the interest of time.
Yes, go ahead, please.
There is no evidence on the point whether Gaitrin undertook to notify these organs. However, what is clear at this stage is that COTET is seized of the matter.
Just one quick question before you complete your submissions, Ms. Mitchell. How do you respond to the contention of Antigua and Barbuda that these are preemptive measures? Article 43, Article 47 requires the state to prove that the exercise of the rights by the community nationals is actually the cause of the hardship in the sector. But with the local content policy having been developed in 2020, the year after oil was discovered, how do you address that particular contention of the state of Antigua and Barbuda, that these are preemptive measures? That you can't demonstrate that the cause of the hardship in the sector is the exercise of the rights by the community nationals?
We assert that there would have been difficulty or hardship even at the developmental stages, considering the petroleum industry requires large infrastructure development output and investment by the government. So although it came before the first oil production, the development of the industry, which would have been happening from the time they discovered oil, essentially, it would not be a preemptive measure. It would be a measure in line with the development of the industry. I will return to the notification.
Yes, please go ahead.
Competent organs. So in response to the development, to the notification, COTED undertook to develop the working group on local content. And we consider that this development is the likely response to any perceived dissatisfaction. and the appointment, as opposed to any immediate sanctions, illustrates some leniency or satisfaction on behalf of quoted regarding local content legislation, policy, or planning. So all in all, if the court should find any violations of Articles 7, 32, 36, and 36, same are justified under 43. So I will quickly turn to Article 47, which I believe we have established the applicability of Article 47. So I would like to zone in on subsection 6, that any perceived damage to other member states would be minimal. The restrictions may serve to develop, and in turn, these restrictions can actually serve to develop the CSME in the long run. Counsel for the applicant oftentimes neglected to acknowledge that Guytrin is a member of the community, and any developments which serve to better Guytrin or bolster its economic standing will similarly benefit the entire community and help to achieve the fundamental objectives. As per Article 6, the community is interested with improvements in standard of living and work, economic development, and international competitiveness. The proposed restrictions in Guytrin can largely and sustainably develop the petroleum industry and in turn realize many of the community objectives.
Ms. Mitchell, if you persuade us on either one of 43 and 40 or 47, you don't have to do, is it your position that you think you may have to justify? I know what your first argument is, but do you feel you have to justify it on both, or is justification on one sufficient?
We believe that justification on one ground is sufficient. So the choice to justify.
If you justify under 43, that's fine. And if you don't under 43 because of the language, but you do under 47, that's equally fine.
Yes, Your Honor. So lastly, I would like to look at Article 47(7) and say that it has not been justified since there is no discrimination against member states and that the failure to relax the restrictions is justified considering the surrounding circumstances as we have established in Report 9.
Yes, Ms. Mitchell, you wish to wrap up? You have just about half a minute.
Finally, in making any determinations, I wish to turn the court to their own dictum in TCL against the Caribbean community. The court must seek to strike a balance between the need to preserve policy space and flexibility for adopting development policies on the one hand, and the requirement for necessary and effective measures to curb the abuse of discretionary power on the other. To this end, while respecting the court's jurisdiction to rule on this matter, in keeping with the court's own dicta, I wish further to urge the court to preserve the policy space of the relevant organs, seeing as this issue is live before the community. The agreement on local content stands to be addressed in a suitable arena where all member states may have a voice in shaping the policy. If I may be of no further assistance to the court, this brings me to the end of my submissions.
Thank you very much, Ms. Mitchell. That's the case for the respondent. Yes, and there is to be a reply for the claimant. Ms. Brown?
Thank you, Your Honors. We would just like to address a few of the points. With your leave, may I proceed briefly?
Yes,
Thank
please.
you.
Just wait for the technician to.
Okay,
Hold on.
yes,
Yes, you may go ahead, Ms. Brown.
yes, Your Honor. Just pertaining to their first point, that the defendant contends that the LCP, being a common practice, suggests it is compliant with the RTC. And the claimants, we disagree and contend that it is no defense to rely on the LCP being a common practice here, especially where it is unknown as to whether those other LCPs are compliant with the RTC. On their second point pertaining to the PSA, they're saying that the PSA is not an act of the state. However, the agreement is clear that it was concluded between the state and Hex Mobile. So we contend that it is an act of the state. As far as their third contention, the defendant contends that the community agreement is not attributed to the state as they do not exercise control over this particular company. Your Honors, the authority specifically says that where the state exercises direction or control, that they can assume responsibility. And we emphasized in our argument, it was direction based on them setting out the perimeters as to how HexMobile is to execute activities within the petroleum sector, and also that direction and control is disjunctive, which means they're separate, and we're focused more on direction. Therefore, we contend that the defendant assumes responsibility on the basis of the direction that is within the PSA and the LCP. As it pertains to the special rights and their mention of the Myalitis case, we are stating that that is not applicable, as the emphasis by the CCJ regarding the special rights of Indigenous people were made during the interpretation of Belize's constitution, and the international conventions are not binding on the international law. And general principles of international law provide that a state may not assert its internal situation. Also, the RTC does not provide for special rights for the Indigenous persons in that regards. We also maintain that the measures are preemptive, discriminatory, and have been in place for an indefinite duration, and that their requirements have not been satisfied, namely the fundamental conditions of notifying the competent organs. Also, we would state that even if the state of or the Republic of Gaitrin is considered a less developed or disadvantaged country, the defendant cannot put in place measures that breach their treaty obligations. Here ends our reply. Thank you.
Thank you very much, Ms. Brown. That brings us to the end of the first session this morning. We take a break, and I do believe that we come back at 11 o'clock. Is that right, Madam Registrar? Yeah, yes. 11?
11:15.
No,
We changed.
I think it's 11:15.
Oh, 11:15. Thank you very much. Okay. Just give us